And this as he's just tweeting away this morning about what he's been calling Obamagate. And yesterday, the president was asked what he means by his claims about former President Obama. Take a listen.
What crime exactly are you accusing President Obama of committing, and do you believe the Justice Department should prosecute him?
Obamagate. It's been going on for a long time. It's been going on from before I even got elected. And it's a disgrace that it happened. And if you look at what's gone on, and if you look at now all of this information that's being released, and from what I understand, that's only the beginning. Some terrible things happened, and it should never be allowed to happen in our country again. And you'll be seeing what's going on over the coming weeks. But I wish you'd write honestly about it, but unfortunately, you choose not to do so. Yeah, John, please.
Crime. What is the crime exactly that you're accusing him of?
You know what the crime is. The crime is very obvious to everybody.
No,
actually, much to unpack there.
It's not obvious to everybody.
Joining us now, NBC News and MSNBC law analyst and editor-in-chief of Lawfare, Benjamin Wittes. And Ben, I mean, aside from the fact that he was run off the stage by two women reporters, one in which he was extremely racist toward, and the other he just ran off, not to get distracted by that, but to go back to this. There is so much to unpack in what that one soundbite. We'll see what happens. You'll see what it is. It's coming out in the next few weeks. You know what it is. I don't. Can you tell us?
I can't, actually. Obamagate is a phrase that seems to have no meaning except to tag his predecessor with some very nebulous scandal. The information that has been released that he refers to relates to General Flynn, of course. It does not in any sense establish that there was any great misconduct on the part of the Justice Department or the FBI, much less President Obama, who was not in office anymore by the time General Flynn was interviewed by the FBI. And so I think this is, really an effort to distract and to mobilize his base and to kind of keep this sense of conspiracy that animates so much of his response to criticisms and allegations against him going and fevered up. And beyond that, I have no sense of what he's talking about.
Well, I mean, and he is. It's conspiracy theories left and right, conspiracy theories about Barack Obama this morning, more conspiracy theories about me, not understanding that doesn't hurt my family or me. It hurts other people, just like his conspiracy theories or other people's conspiracy theories about Seth Rich hurt Seth Rich's family. But the conspiracy theories fly left and right. And let's get to facts, because, this past week, some of Barr's defenders, the anti-Trump squadron out there with their fainting couches, were talking about how Barr was attacked unfairly for what he did. Yet you said that Barr's actions were exceptionally rare. Explain why.
Well, I am unaware of a single other case, and no one has cited me one, in which the Justice Department, without acknowledging that there's either newly discovered evidence of innocence or discovering that there was some deprivation of legal or constitutional right on behalf of the defendant, moves to dismiss a plea. It's not like it's a case that hasn't gone to trial yet. This is a case where the man has been convicted by his own plea that was entered voluntarily. I just don't know of the Justice Department doing that. Now, it's not common, but it does happen that sometimes you get a plea deal and then there's, kind of evidence emerges that the person was innocent. Well, that's not what happened here. And there's sometimes you find out that there's egregious government conduct that, you don't want the government to obtain a conviction by that means because it violates somebody's constitutional rights. That I understand. But that's not what happened here. The government does not allege in Bill Barr's new brief that the government abridged General Flynn's constitutional rights. And so the idea that the government would basically throw its own case in a situation like this is, to my knowledge, unprecedented. And, I have asked a bunch of people whether they can cite me a case in which the government behaves this way, and people can't. So that's what I was referring to when we said it was exceptionally rare.
And of course, General Flynn admitted to it. He pled guilty to it. Donald Trump said he lied to the vice president and the FBI. So Donald Trump said he had to fire General Flynn. You had Mike Pence. Hold on one second. You had Mike Pence saying that General Flynn lied to him and had to be fired. So the question, Ben, is this. Why in the world would Judge Sullivan let the prosecution basically throw this case out for clearly political reasons? Could the judge still make this case move forward?
So it is very difficult under precedent in the D.C. Circuit, where this court is, where Judge Sullivan sits, to not accept the government's move to dismiss. And I think at the end of the day, Judge Sullivan may well be bound by precedent to grant the government's motion. That said, he can ask questions. And, the government has a motion before him to dismiss. That requires leave of the court in the language of the rule. And before he grants his leave, he can hold their feet to the fire about this, and he can ask about, as you point out, the role of politics. He can ask about why not a single career Justice Department official was willing to sign this extraordinary brief that they filed. He can ask about whether the Justice Department has ever taken a position like this in the history of the Republic. He can ask about whether the Justice Department is willing to be bound by this precedent in the future and behave this way in future cases. So Judge Sullivan can make things very uncomfortable for them. I don't know if at the end of the day he can force them to continue litigating a case that they don't want to litigate, but he can certainly raise questions in the meantime.
John Heilman's with us and has a question. John.
Hey, Ben. I was really struck yesterday by this letter, 2,000 former DOJ employees, prosecutors, mostly career officials, former officials, who wrote this letter and said that Bill Barr should resign. You were just talking about a number of things that have no precedent in the Justice Department in terms of how this case has been handled. Have you ever seen anything like this with, that kind of bipartisan, large-scale outcry from the career officials who make up basically the alumni of the Justice Department coming out and taking a stand that strikes me as totally extraordinary, but I'm curious as to whether there's any precedent for that, and I'm just ignorant of it.
The only precedent of it that I'm aware of is that the same group of former DOJ officials released an earlier letter about Bill Barr's conduct. But, if you take those two statements together as kind of one, this sort of former alums of the department of both parties, some of them at extremely senior levels, denouncing the Attorney General's behavior, I am unaware of a precedent for that either.
All right. Willie Geist.
So, Ben, I want to ask you about the judgment by by Attorney General Barr, that the lies told by Michael Flynn, again, the lies that he copped to twice, that he pleaded to lying to the FBI investigators, were not material, that this was withdrawn, the prosecution was withdrawn because the lies were not material. How did they arrive at that conclusion? What does that mean in this case?
Okay, so this is the core dishonesty of the brief, and the basic theory of it runs like this. Let me sketch out the theory and then, like with an example, show you why it is so ridiculous. The theory goes, there was no legitimate basis on which to be investigating General Flynn because the FBI had considered and even moved toward closing the counterintelligence case against him when they suddenly renewed it because of this information about his conversations with the Russian ambassador coming to their attention. So there was no proper basis for them to be investigating him. Therefore, there was no proper basis to interview him. And if there's no basis to interview him, then the answers that he gave in those interviews, even if they're lies, cannot be material, which is a requirement of the statute. So therefore, he couldn't have committed a crime. Now, if that's right, imagine that instead of Flynn being interviewed, you had made a malicious complaint against him to the FBI. And the FBI, you had said, you know, General Flynn's a Russian agent, and by the way, he's a child molester, and you'd made up all sorts of false things about him. And the FBI had come to interview you about your allegations. Now, there's no open investigation at that point. They're just, they're just interviewing you about your allegations, and you've now lied and committed and submitted a false report against somebody, a maliciously false report. According to this theory, you couldn't be charged for that because there was no open, validly predicated investigation when you submitted that false report. That cannot be right.
Benjamin Wittes, thank you so much. And as President Trump...
Thanks for checking out MSNBC on YouTube, and make sure you subscribe to stay up to date on the day's biggest stories. And you can click on any of the videos around us to watch more from Morning Joe and MSNBC. Thanks so much for watching.